Thank you, Your Honor. Your Honor, we're here this morning, case captioned State of Ohio versus Stephen Pekarski, case number 25CR000882. We were last here on January 27th, at which time the defendant entered a written and oral plea of guilty to count 3 kidnapping, a felony of the first degree, in violation of Revised Code Section 2905.01B1 of the Revised Code, was a 3-year firearm specification as set forth in Revised Code Section 2941.145, and count 5 felonious assault, a felony of the second degree, in violation of Revised Code Section 2903.1182, and a 3-year firearm specification as well on that pursuant to 2941.145. At that point in time, then the court referred it for a pre-sentence report and investigation, a victim impact statement, drug and alcohol evaluation, and psychological. Those have been completed, and we are here today for purposes of sentencing. The defendant is present with his counsel, Mr. Myron Watson.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Is there anything you would like to say at this time on behalf of your client?
Yes, I would.
Go ahead.
Yes, Your Honor. I would like, for the record, just to incorporate the sentencing memorandum and the letters of support about Mr. Pekarski. We are not in any way, our comments are not designed to minimize what happened here.
Well, I'll incorporate the sentencing memorandum that was filed. You also had lodged an objection based, recognizing that what the law is in Ohio at this time, but still lodged an objection, understandably so, in case some reason the law changes on that in that aspect in regards to the firearm specifications in the Bowler case. And that will be, that objection I will recognize for the record is timely made and is being preserved for the record. I will state, at least from the court's position, that the charges in this case are not allied offenses, and they would not and will not merge for purposes of sentencing, which I think distinguishes this from Bowler, but nonetheless, your objection is recognized and noted for the record.
Thank you very much, Your Honor. We believe here, when the court looks at the statutory requirements in imposing a sentence that, promotes rehabilitation as well as the punishment aspect of it, we believe that a 9-year sentence would meet that requirement, Judge. And the reason why we take that position is that the lack of Mr. Pekarski's criminal history, he does show remorse, and he will allocute on that fact. You can see from the letters that have been presented by family members and friends, they truly believe that this person generally has a good soul. I think what's also mitigating here, Judge, is you have Mr. Pekarski, who, for a difficult childhood and early drug use, and I mean, it was kind of shocking to know that his introduction into drugs was at a very tender age. He's tried to work and get over his addiction, but it's come with some hiccups and some missteps, which typically does happen for people who are chemically addicted to heroin and amphetamines. And I think what's mitigating here, Judge, is Mr. Pekarski was in a long-term relationship with the complainant in this case, the victim in this case. There was a very emotionally charged issue about them having a child and his level of participation in that with regard to that child. I think that is factually not in dispute, that the argument and the disagreement and the later actions on his part, wrong, no doubt, but mitigated by the strong emotional situation that he really wanted to be involved with the child. And things spun out of control, and he was not thinking clearly because he was intoxicated, he was under the influence of drugs. That's not an excuse, and we're not using it as an excuse, but we're saying that based upon our contact with the complainant in this case, they feel like he's a good person. And that when our people interviewed the complainant in this case, they indicated that they wanted lenient treatment for him. That at some point when he's gotten his act together, to forge a relationship with his daughter. Mr. Pekarski worked as a carpenter, worked very hard at it, was very good at it. But he had a bad misstep here, Judge, and there's nothing to minimize that. If there's any suggestion in my sentencing memorandum that I didn't believe that this was serious, that's not the case. And he's always acknowledged that he felt that it was serious. His overriding belief that he wanted to be a part of his child's life, and wanted to be a part of a family relationship with the complainant in this case. We're hopeful that the court will take in both the psychological report, which indicates that he was suffering from major depressive disorder, that he's had some mental issues going on that are currently being addressed. And we would hope that the court, with the proper programming and the proper working hard with the tools in which the prison will give him, will help him get over some of his problems and eventually be able to re-enter into society. We're optimistic about that. His mom is here, his sister is here. They're rooting for him. They love him and they care about them because they know what the struggle has been for him. And I know that the state probably said that it's not something that the court should give a great amount of weight to, but we will hope that the court will see its way clear that 9 years is a very long time for someone to be incarcerated, and that would not demean the seriousness of what happens here. And I believe that the complainant, and I think the court may remember that there have been a discussion as to the complainant, the person who has to raise the child on their own, the one who knows this man probably better than anyone else, felt that he should get some level of leniency despite the fact that the state will probably be asking for a sentence above the minimum. And I believe that Mr. Pekarski wanted to address the court as well.
Certainly, he has a right to address the court. And you do have that right, Mr. Pekarski. You can say anything you want this court to consider before sentencing. Is there anything you'd like to say at this time?
Yes, Your Honor. I'd just like to say that I'm very sorry for what I've done, and I just hope that I can be forgiven and I can be in my child's life, and there's no excuse for what I've done, and I'm very sorry. I've had a lot of time to think about that, and I'm sorry.
Okay. Thank you, sir. Mr. Watson, is there anything else you would like this court to consider? Any other comments you want to make? You don't have to, I just want to make sure you said everything.
No, Your Honor. Thank you.
Ms. Linden, on behalf of the state of Ohio.
Thank you, Your Honor. Your Honor, as I indicated in chambers, the state is recommending a prison term of 15 years, 6 years for the firearm specifications, and then 9 years on the underlying. As I indicated in chambers, the credit is not 259, it should be 94 days. He did have a new offense that's not listed in the pre-sentence report for violating a protection order for his contact with the victim while he was in the jail. He was serving a sentence from September 2nd of 2025 until February 14th of 2025, so he would not get credit because he was serving a sentence during that period of time. Also, as I indicated in chambers, I want to place on the record that I take issue with what the sentencing memorandum says about the victim recanting. That is simply and absolutely 100% not true. She has been consistent from the day of, even in looking at her voluntary statement from June 11th of 2025 when this happened, and up until right before trial. Never once did she change her story. Yes, she felt bad for the defendant. She felt that maybe he had a mental break. She knew that these charges were serious, but never once did she waver. And quite frankly, I thought that maybe at some point in time she might, since she was talking to him on the phone. And when I asked her about it, she said no, she wasn't talking to him. Even though I knew that it was her, and I knew that they were speaking on one of his old phones. So I want to clear that up because that's, in incorporating the sentencing memorandum, it should be noted that that's not true. When looking at the pre-sentence report, one of the things that I found very lacking was the defendant said that he was just glad that he didn't hurt anybody. And I guess he doesn't realize or can't grasp the extent of damage that he has done. The victim in this matter was so terrified that she ended up getting a protection order. And when you look at what happened that day, it started in the morning when she had been at his mother's house with him. She said she was going to look for an apartment. The defendant was mad about that and was not going to even let her leave the house that morning. When she finally did get a chance to leave, he followed her in his car, was swerving behind her, and she felt that they were going to get into an accident. Now, this is somebody who's saying that he wants to be in his child's life, but he knew full well at that point in time that she was pregnant. That he didn't seem to care about that. Shortly after, Nikki ended up pulling into American Electric, a parking lot there. And the defendant, you can see on the video, you can hear his tires are squealing, comes around, and he slams into the back of her car. She was on the phone with her mother when this happened, and her mother could hear that. He then takes off. She goes to the police department. She says, you know, I don't want to file charges on that, but I want you to know. And the defendant is told to leave her alone. So after that, she's getting ready to go home, and she's on the highway, and the defendant is behind her, and then in front of her trying to brake check her, and she's on the phone with her mom. She's in a panic. Mom says, hey, let's go to the Vrooman Road gas station. We'll go there and maybe we can talk. The defendant follows her there. I don't think the defendant realized that her mother was there at first, and she says, just, you know, leave this alone. Someone's going to get hurt. Now, I will say that Nikki did at one point in time, after they parted ways, say, you know, we're going to have a child together, maybe he could come over for a cookout. Invited him to come over to her mother's house for a cookout. He didn't come. It gets to be 11 o'clock at night, and the defendant shows up, pulls into the driveway. Victim sees that he is in the driveway. She comes out in her pajama pants, no shoes, no socks, no phone, basically in her pajamas. As she comes out to the truck, the defendant tells her to get into the truck, and she says, no, I'm not going to get in. He then pulls a gun and says, get into the truck. She doesn't want to get in, and so he grabs her by the back of her hair and he throws her in the truck. Again, she's pregnant. He knows this. They're driving around, and while they're driving around, he's yelling and screaming at her, saying, this will all be over soon. I'm going to kill you. I'm going to kill myself, and she's terrified. So this has gone on from morning until late at night. He even takes her at one point in time down a road, Wood Road, and that's actually where her sister had died as a result of a car accident. Drives her through that area, still saying that he's going to kill her. And whether you believe what he says to the police, that at some point in time they're arguing and he stops the car, shoots the gun off, and it goes through the roof of the car, or what she says is that he's so angry that he's slamming his hands on the steering wheel that he has the gun in his hand and it goes off. Not only that, but then he's slamming the gun on her leg to the point where she gets bruises. He tells her when they go to his house, they go back to his house. This is all the way from out near Madison Avenue, takes her all the way to Geneva, tells her don't do anything funny when she goes inside the house, gets her back into the car, and luckily he then takes her over to the gas station. And when he goes over to the gas station, he has to go inside, and you can see on the video of her, as soon as he goes inside and that door is closed to that gas station, she hightails it out of that vehicle and she runs over, and luckily she's across from the Geneva Police Department. She is trying to open those doors, looking. And when I talked to her about it, I said, you know, why'd you keep looking back? She said the thing that scared her the most is that she was going to get shot in the back. She then goes around to the back of the police department. She's banging on the doors there, and luckily one of the officers lets her in. Normally, nobody would come in that way. All the doors have been locked. And then you see him on the videos driving past the police department, driving back and forth looking for her, still even after that. Now, one of the officers from Geneva saw the truck, and so when she goes inside and describes the truck, one of the officers realizes he has just seen that. He goes and he ends up pulling the defendant over while he's pulling into where he lives. He ends up He does have the gun in the car. I'm not sure at what point in time he unloaded the magazine of the firearm. But one of the reasons that we know the magazine was still in there for a period of time is not only did that one bullet go through the roof of the vehicle, but there was still one in the chamber. And although the magazine had been taken out and there were rounds all over the car, there was still one in the chamber. And unless he actually put that in himself, it fed from the magazine. The other thing that was interesting, and talking to the Geneva Police Department, they couldn't figure out why when they went up to the truck the first time, they could hear their voices and they could hear dispatch. The defendant had a second phone in his car, and he had this app called Broadcastify on his phone, listening to what the police were doing. So when you look at all those factors and how long this incident occurred, and then the defendant saying no one was hurt, he clearly doesn't understand that emotional and physical are both injuries. So when you look at the facts and circumstances of this case, having 15 years and asking for 9 on the underlying, I don't think that's out of the realm of what's appropriate at all. The minimum would completely demean the seriousness of this offense. This is one of those situations where when we talk about kidnapping, sometimes it's the technical violation, it's a kidnapping. This is why the statute was written. And we would ask then that you give the 6 years on the underlying offense, and then 9 years, or I'm sorry, on 6 years on the firearm specifications, and then 9 years on the underlying offenses, however the court deems that that would be appropriate. There is no merger. These are separate and distinct offenses.
Thank you.
Judge, can I respond just briefly as
Sure.
the recitation? I think, yes, this was an unfortunate circumstance, but I think the prosecutor left out is that the complainant in this case, along with mom, had invited my client to the home, so it wasn't like a situation he popped up
She said that.
unexpectedly. Huh?
She said that.
Oh, I missed that part. I missed that
Yeah,
part.
she said that they invited him and he didn't come.
Okay, yeah. So my apologies.
That's all right.
I didn't hear that part. Thank you.
This court has reviewed the pre-sentence report and investigation and psychological evaluation. I have considered the facts and circumstances of the offenses involved, the nature of the offenses involved. I received and reviewed the sentencing memorandum filed by Mr. Watson with the accompanying letters, and I've read all that, taken that into consideration. I have considered and read and considered the victim impact statement that was received by this court. I've also considered everything that's been said here in court by Mr. Watson on behalf of his client, the defendant himself, his comments, the prosecutor's comments, the recommendations from all parties. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11 of the revised code. As for the factors in 29-29-12, factors indicating the conduct is more or less serious, the court notes that in this case, the victim did suffer serious psychological harm, that the relationship with the victim facilitated the offense, and other relevant factors indicating the conduct is more serious is the fact that a firearm was used in this offense and actually was discharged, and also the fact that the victim was pregnant in this case. Those are all factors indicating the conduct is more serious, and he knew she was pregnant. Nothing makes it less serious. As for recidivism factors, court knows that the defendant does have a couple prior convictions. I'm not going to say a history of criminal convictions. I don't believe it's a history, but there was a theft conviction, misdemeanor theft conviction back in 2014. Drug paraphernalia charge around the same time, 6 months later. And that was it until this case occurred. There is a conviction also for violating protection order that occurred after this happened and basically related to this, but there is a conviction for that, but was not prior. So he has 2 misdemeanor convictions that occurred about 10 years ago. In that 1 misdemeanor, there are probation violations that were filed, so he did fail in the past to comply with the previously imposed sanctions ordered by that court. Obviously failed to comply with the orders of a court with the TPO violation as well. Factors indicating recidivism is less likely. There's no delinquency adjudications, and the defendant did lead a law-abiding life for a significant number of years. Again, I mentioned the 2 misdemeanor convictions were 10 years ago. In this case, prison is mandatory due to the firearm specifications. Prison is consistent with the purposes and principles of sentencing, and the court notes for the record, defendant's not amenable to available community control sanctions. Therefore, it will be the sentence of this court that on count 3, the defendant serve an indefinite prison term of a minimum of 4 years, maximum of 6 years. On count 5, he serve a prison term of 4 years. The prison terms will run concurrent with each other. However, both counts carry 3-year mandatory firearm specifications, and those will be imposed for each count to be served prior to and consecutive to each other, and consecutive to the indefinite prison term of 4 to 6 years for an aggregate indefinite prison term of a minimum of minimum of 10 years, maximum of 12 years. There's credit for 94 days that he served. The other time that he was in jail, he was serving a sentence for the protection order violation, the TPO violation that he was convicted of. So he's credit for 94 days. As far as the consecutive sentences go in terms of the firearm specification, those are statutory and required and mandatory, so there's no findings that need to be made for that. I need to advise you upon your release, you will be placed on post-release control for a minimum of 2 years. Could be up to 5 years. That's up for the parole authority to determine. When on post-release control, if you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Balance of the indictment will be dismissed. Defendant's ordered to pay all costs incurred in this action. Further need to advise you that you have been sentenced to a non-life felony indefinite prison term, and I need to advise you that there is a rebuttable presumption that you will be released from the service of that prison sentence after you have served the minimum sentence. So you first have to serve the firearm specifications, then you'll begin serving the indefinite prison term of 4 to 6 years. There's a presumption you'll be released after you've served the 4 years of that indefinite sentence, but that's not guaranteed. Department of Rehabilitation and Correction, if they determine that while you're in prison that you have misbehaved, you haven't followed the rules of the institution, that you remain a threat to the community, you're not sufficiently rehabilitated, they can schedule a hearing for the purpose of keeping you in beyond the minimum sentence. You'll have a right to attend that hearing if that should happen. If they make that determination, they will then not release you. They'll schedule a new date for you to be released. There'll be a presumption that you'll be released at that new date. Again, unless you've misbehaved or a threat to the community, not rehabilitated, there's a presumption you'll be released. If they have a hearing again, because they don't believe, they believe that you have violated the rules, misbehaved, they can do the same thing. Under no circumstances, however, can you be kept in beyond the maximum sentence of the 6 years, beyond the first 6 years. I think that covers everything. Ms. Linden, is there anything else for the record that we need to address?
No, Your Honor.
Mr. Watson?
Only that we would like to make requests for a waiver of any costs. He's indigent. He's been incarcerated for some.
Court costs are going to be imposed. I'm not imposing any fines, but there's going to be court costs.
Thank you, Your Honor.
And just for the record, I don't have any, I know that was mentioned in the, I think, the victim impact statement as well as maybe your memo. I don't have any control in designating where Mr. Pekarsky will serve his time, so that's up to the prison officials for that.
Yes.
All right, thank you.
Thank you.
All set? Right this way.
What you assume. You know what, let me know, I know that Rocco's on call now, but let me know with yours. I'll go ahead and do that other section for you.
I'll send it over.
Okay.
Thank you.
Yeah, no problem.
Thank you again. Until next time. Be safe out there, man. You as well. Yes, sir. Yes, sir.
Okay, I'm really mad about that. But the thing is, it's part of a record now, and so now I have to file something saying that that's not true, because I need to make it part of the record. It was just, it was one of those things, I read that, I'm like, what?
Guys, I don't mean to rush you, but I have a 9:30 that we're behind.
You know, Taylor, because you know what I said.
I know, but that's why I was like flabbergasted
And
by
I
the
missed
second part of
And
that.
I missed it. But I'm ultimately
Okay.
responsible for that. My apologies.
I'll
It
take
wasn't,
that.
it wasn't intentional.
And okay, we're out. But you know what? We don't need anybody here. Go ahead. Okay, well, let me check the date. I'll come right up.
Okay.
Come in, need your family, get to sit over here. Thank you. No, you're fine. I can tell you're fine.
I don't know you.
Don't worry, that's not on.
No, I just want to kind of let you know.
I appreciate
Make
that.
yourself over, all right?
They're all off.
No, that's fine, perfect.
Deeper, take a seat. Make sure your phone's off.
Yeah, I don't even have it.
Dude, I know that you were anxious and nervous, but I can guarantee you this courtroom gives me PTSD, because this is where
not the right one. Well, we're here for an arraignment on a new indictment that was just filed. All right, we are here in case 25 CR 1685, State of Ohio versus Keith Romig. Superseding indictment was filed on February 20th, 2026. We're scheduled for an arraignment on that new indictment. Defendant is here in court. He's with attorney Mr. Neil Harrison, who just recently entered an appearance. Prior counsel subsequently, upon entering the new notice of appearance, withdrawn from the case, so we're all square there. Mr. Romig, did you receive a copy of this indictment?
Yes, I have, sir, Your Honor.
Had a chance to look that over?
Yes, I have, Your Honor.
You have the right to have me read that indictment to you if you'd like, and I'm more than happy to do that, but you can also waive the reading of the indictment. What would you like to do at the time?
I'll waive it.
Okay. Very well then. As to the one count of this indictment charging with insurance fraud, a felony of the 4th degree, what is your plea to that count at this time?
Not guilty, Your Honor.
All right, the court will enter a plea of not guilty. Bond was previously set and has been at the defendant's own recognizance. Is the state looking to modify that in any way?
No reason to change that.
All right. The bond will remain at the defendant's own recognizance. What that means, I told you this before, but I'll tell you again for the record. You have to show up at all future court dates, and if you fail to appear at any future court dates while released on an own recognizance bond, that is a separate felony, which is the same degree of offense that you're charged with, quite frankly, that you can be prosecuted for and receive up to 18 months in prison in addition to whatever could happen on the underlying offense. So it's obviously important to show up at all future court dates. The next court date is next Tuesday, March 3rd at 8:30, where we have a jury trial scheduled. So I need to make sure you're here for that. So, Mr. Harrison, you just entered an appearance. It's your intention you prepared for trial for next week?
Your Honor, we're preparing for trial, but in our preparation, we may have discovered evidence that could cause the state to dismiss the complaint.
Are you aware of that, Ms. Mulligan?
We were going to talk about it after the hearing, Your Honor.
We are still discussing this case, yes, and I imagine
Well,
we'll continue.
we're scheduled.
I
We're
don't know.
scheduled for trial. If the state does not go along with your request and dismiss the charges, you're planning on going?
Absolutely, Your Honor.
Okay.
Yes, but
Then we'll be in trial next week on Tuesday. It's beyond the 2-week rule, so it's either going to be a trial or a dismissal or a plea to the indictment, one of the three. There's not going to be a plea to any lesser offense. That ship has flown. So
Yes, Your Honor.
that makes sense. The ship has flown now. Ms. Mulligan, anything else?
No, Your Honor, thank you.
Mr. Harrison,
Thank you, Your Honor.
I await your dismissal, Ms. Mulligan.
All rise.
cases, all entitled State of Ohio versus Curtis L. Wilder. Those case numbers being 25 CR 001550, 25 CR 001551, and 25 CR 001737. Defendant is present and open for today with his counsel, Corey Hinton. We're here today for sentencing on all three cases. The defendant was last before Your Honor on January 13th of 2026, where he pled guilty by way of information in each of the three cases. In 1550, he pled guilty to 1 count of grand theft of a motor vehicle, a felony of the 4th degree, and 1 count of grand theft, a felony of the 4th degree. In 1551, he pled guilty to 2 separate counts of grand theft of a motor vehicle, felonies of the 4th degree, and 1 count of breaking and entering, a felony of the 5th degree. And in 1737, he pled guilty to 2 separate counts of grand theft, felonies of the 4th degree, and 1 count of theft, felony of the 5th degree. At that time, the pre-sentence report and victim impact statements were ordered. It's the state's understanding that the pre-sentence report has been completed and provided to the court, and that multiple victim impact statements were also submitted. And it's the state's understanding that all parties are prepared to go to sentencing at this time, and that's the state's understanding at this time.
Thank you. Mr. Hinton, is there any reason not to go forward with sentencing? I did receive your sentencing memorandum and have read that. Any reason not to go forward with sentencing?
No such reason, Your Honor.
Is there anything you'd like to say at this time on behalf of your client?
Yes, Your Honor. There are quite a few things I'd like to highlight. As you know, based on the sentencing memorandum and the letters that I attached, Mr. Wilder, he's a father, a son, a friend of many. Certainly has a lot of good characteristics that these folks are seeing in him. He served our country as a Marine. Unfortunately, the drugs got the best of him. Him and I have had a lot of conversation about that. I know that these offenses here were directly related to drug use. I do know that despite that, it's my understanding that Mr. Wilder was cooperative when he was apprehended, that he gave information regarding other cases of his, that he helped locate some of the vehicles. I know that he was last in treatment in Euclid, and it is demonstrated in the pre-sentence report. I had asked him about that, and that appears to have been more of a detox facility as opposed to anything long-term treatment. He does indicate that he made arrangements and does have a bed available at the Salvation Army. It's a 6-month program there. I talked to him about maybe looking at the VA or other resources as well. He indicates that he's not on probation or parole to any other court. I spoke to Mr. Wilder about restitution, and that there is restitution being ordered or being requested and likely ordered. In this case, did indicate to me that he is employed as a CDL. I did ask him about his license because I noticed in the pre-sentence report that there wasn't a valid license, but he seems to be able to get that back, and it may have expired. So he does have work available to help him with the restitution. But I think getting to the bottom of the drug issue is certainly important here. I understand that there is a lengthy history, that there has been 12 prior prison commitments, so that's not something I'm blind to or that my client's blind to, but I know he has a good heart. He certainly wants to get better for himself and his family, especially his son. With all that said, Your Honor, we would ask that you consider community control. Again, I know with prior prison sentences and other things, what would normally be a presumption for community control with felonies of the 4th and 5th degree can be rebutted. But we would ask you to consider that. If the court did not think that community control was appropriate and instead was going to order a prison sentence, I would ask the court to consider something less than 5 years, and I think that would open the door for the possibility of requesting judicial release at a reasonable time so that, again, this idea of treatment can be explored. I know that there's an individual here, Frank DeMario, that wanted to speak as far as the veteran component goes. I did speak with Mr. DeMario to see what he would be speaking about. I have no issue with him speaking. Neither does my client. So with that said, Your Honor, I'd like to call Mr. DeMario as a witness if the court would so allow.
Sure, sir. You can just stand right where it is that you're seated, state your full name for the record, and state whatever you'd like me to know.
Yes, Your Honor. My name is Frank DeMario, DeMario. I'm a retired federal agent, retired supervisor at Lake County Narcotics. And I've been working with incarcerated vets for the past 3.5 years. I've been working with the defendant for the last few months. And we've been talking about the importance of him setting a good example for his 14-year-old special needs son. And he understands that. And he understands that the importance of his son in his life. And when his son was taken by his mother for 4 months, he did not know where his son was. And he was finally found by the proven police. That's the time that he began using again and committed these crimes. I believe that with rehab, he would be able to overcome the use of crack, which he's addicted to. I would ask that he be considered for treatment, Your Honor, in order to get his life straightened. Thank you very much.
Thank you. Mr. Hinton, anything else?
Your Honor, I know my client would
sure.
like to speak, but nothing further from myself. I just would like to reiterate what I said, what I indicated in chambers, and what I indicated in writing prior to the hearing.
Thank you, Mr. Wilder. You have all 3 of these cases, and now 3 of these cases you have the right to address the court before your sentence and say anything you want me to know. Is there anything you want to say at this time?
Yes, sir. I do apologize to people that I harmed, taking their stuff. My son got kidnapped, kind of lost faith after a while, lost hope, couldn't find him, didn't know what else to do, turned to drugs, and that's how I currently in this situation. I had a pretty lengthy criminal history. Been out of prison for 7 years. It's the longest time I've ever been out of prison. I had a couple of relapses in the process, but nothing that led me to crime until after Nasir was kidnapped and I lost hope. I ended up losing my job at Ford. From there, I started using a little more heavy, and then I was trying to hide myself and still support my drug habit and pay my bills, and it didn't work out like that. And I was arrested by the Willoughby Police Department for the Wycliffe Police Department. I took them to 2 vehicles that they told me about. They showed me and asked me what I know about. And I just asked for an opportunity to probably try to help some treatment to get my life in order at that point. I was really tired and lost. This officer here told me about his family, and I told him about how I ended up in this situation. We spoke at length that day about it. Tried to contact him, but I didn't know what to do. The officer behind me was the arresting officer, but I didn't know who was what. I've tried to do as much as I could to right my wrong, and I do apologize for any harm I caused anybody. Given the opportunity, I will do better. I'm just trying. Sometimes I just don't know what to do. I ask for help to try to get as far along as over the hump to be a better person. just asking for a chance. I don't care what the length is, if it's however long treatment may be, 2 years, a year, whatever it may be, I just want to try to get my life together. Thank you, sir.
Thank you. Mr. Hinton, anything else?
Nothing further, Your Honor.
Special for the State of Ohio?
Thank you, Your Honor. These cases go back to August of 2025 all the way through the end of October of 2025. Law enforcement made the decision, so they were investigating both Wickliffe Police Department, Eastlake Police Department, Willoughby Police Department, and Mentor Police Department were all investigating various thefts of vehicles, trailers, and equipment. When they determined who the individual was, they were still investigating, but because of the continual nature, including incidents occurring in other counties such as Summit County, they made the decision to arrest him as soon as possible, because there seemed to be no stopping the number of places that were broken into, the items that were taken. So the reason this stopped only had to do with law enforcement working very hard to locate, determine, and connect this defendant to each of these locations through his cell phone, through flock camera, through videos at different businesses, whether it be the business that was actually the victim or businesses that were around. They used a lot of different aspects to determine who was breaking into these different places, taking our items, things of that nature. So it was an investigation that 4 different departments were involved in, with Wickliffe and Willoughby being 2 departments that, between getting the warrant through Wickliffe Police Department's cases and then Willoughby making the actual arrest, they all worked hand in hand to bring these cases to the court. So the victims did suffer economic harm as well as psychological harm. All of them had economic harm, which I will go through, but the smaller businesses also struggled to continue their business and their work. There were some bigger companies that were able to replace things quickly and easily and get back to work, and then there were smaller companies where one individual indicated to me that Mr. Biddick, that he found out his insurance did not cover his tools. So he was unable to get insurance for those things. So he had to start replacing tools as quickly as he could to continue with jobs. He couldn't do all of them at the same time because it was a large expense. Mr. Walker also had that issue with being able to get back to work to replace the tools. Because even when insurance did help, they still had to be replaced, even if the money wasn't as large of the issue as it was trickling down. So we have in 1550, Nicholas Spancara, he had his pickup truck taken. Insurance did cover some aspects, but he is out $1,743.82. Then we also have Bernard Giannetti Landscaping. He had equipment from 3 different trailers. The trailers were broken into and the equipment was taken. He did have some insurance. He was able to recover some, but out of pocket was $3,188.09. He also indicated his concerns with having his equipment taken again, something happening, that he did install a fence around the property in hopes that this would not happen to he and his company again. That fence cost him $16,900. In 1551, we have Gregory Ambrose. Insurance did cover some, but I believe his victim impact statement indicates he is still out $8,572.85. Mr. Tyler Hart had to pay his $1,000 deductible. Mitchell Archibald is the breaking and entering charge. His door was damaged. He did not get me the receipts, but he did suffer economic harm. This was the second time in a week that his business was broken into. Arch Landscaping, that did affect him as well. In 1737, we have Abram Biddick. who his insurance was not covering what he needed to replace. I believe he sent a victim impact statement in for $6,925. Mr. William Snow had some insurance. I believe his victim impact statement ended up being approximately $4,138.99. And Mr. Joey Walker indicated his deductible was $500. I did speak with all of them personally, and they were all obviously very upset at the effect it would have on their business and moving forward, and just how it affected them in general. If people would go onto their property and either take their trailers or their trucks or break into either buildings or trailers to take large-scale equipment out that is not easily replaceable, and obviously they built up over time to have successful businesses. This is part of organized criminal activity. Besides the defendant admitting that he was stealing with others, the video evidence also shows at multiple locations, multiple people, whether you saw people together or they came in multiple vehicles, so clearly there had to be more than one individual there. Show that he was working with other people to take these items away from these victims. Before the cases in Lake County occurred, there were also in the beginning of August cases or reports taken for Stowe Police Department, Bath Police Department, and Twinsburg Police Department. At least one of those has charges out of Summit County, the Twinsburg case. So he was doing this ahead of time, and it's the state's understanding that he was on bond at the time he was committing offenses. He does have a history of juvenile adjudications and criminal convictions. It is a very extensive list that the pre-sentence report lays out, with it beginning in 1993, where he did do his first prison sentence in 1993. Per probation, he has 29 felony convictions and 13 misdemeanors. Throughout the years, he has convictions for property crimes in 1993, 1994, 1995, 1997, 1999, 2000, 2001, 2002. In addition, in 2002 to property crimes, he also has domestic violence, as well as trafficking in cocaine, preparation for sale, and possession. In 2003, he has property crimes. In 2004, he has drug and assault charges. He also had I failed to mention in 1994, there were probation violations. In 2004, is a probation violation. Those convictions continue in 2005 with property crimes. 2006, he has property crimes as well as an attempted robbery. 2007, more theft convictions. 2008, he has a failure to comply as well as drug charge with probation violations on the failure, at least one of the charges. He had probation violations in his 2008 failure to comply when he was given judicial release. So he initially went to prison, was given judicial release, and had multiple probation violations. The same in the 2007, one of the theft cases. In 2010, he has more property crimes. He had probation violations in 2 out of the 3, and eventually went to prison after violations. 2011, receiving stolen property. 2012, he has breaking and entering convictions, as well as attempted engaging in a pattern of corrupt activity, grand theft of motor vehicle, possession of heroin, receiving stolen property. It's the state's understanding restitution has not been completed in those cases. He also in 2012 has a federal conviction for theft from interstate shipment, trafficking in certain vehicle parts, altering VIN, operating a chop shop, and conspiracy to operate a chop shop. He was released from that prison term in October of 2019, and he was placed on supervised release, which ended in April 10th of 2024. He had multiple violations while he was on supervised release, with new cases as well as testing positive. I believe it was for both cocaine and heroin. And then in 2021, he has additional convictions. One of them is for theft, felony to the 5th degree, where he was put into Veterans Court. He had 8 probation violations in that case. And then he had another grand theft where probation was unsuccessfully terminated And then in 2025, he has receiving stolen property as a misdemeanor. He has multiple pending cases and/or warrants out. There are 2 Cuyahoga County felony cases, Maple Heights Police Department and Brooklyn Heights Police Department, for felony property crimes that warrants were issued in November of 2025 for failing to appear. And then the Twinsburg Police Department Summit County case I referenced, he is pending grand theft, felony 4s, 2 counts, with a warrant issued in December of 2025. So based on probation's count, there are approximately 12 prison terms, one of them being a federal prison term, and this is on 23 different cases where he was sent to prison. There was one issue in jail that the state is aware of involving an assault. His conduct has been very similar through thefts, breaking and entering, and receiving stolen properties. He did indicate an issue with drugs. We are not denying that. He has had many opportunities for treatment that are outlined in the pre-sentence report going back to 1994 per defendant, all the way until 2025. And it appears, if I have the dates and understanding correct, that when he was in Glen Bay from June of 2025 to September of 2025, that he was engaged in multiple of these offenses. 2 of them in Lake County occurred on August 5th of 2025, and then there were some on August 2nd, 2025 in other jurisdictions. Based on all that, the state does feel that he's not amenable to community control and that prison is consistent. His last Ohio prison term was 5.5 years. I am unclear on what his federal prison term was, looking at my notes. But we do feel that prison would be appropriate in all of these cases, and it should be substantial, especially based on just getting off of supervised release in 2024 in April, and then between a year and a half later, he's engaging in all of these activities. So prison has not seemed to change his attitude on engaging in these activities, and punishment is appropriate in this case. So we would ask for on the high end of prison, but over the most recent prison term being 5.5 out of Ohio, we feel it should be greater than that number. He has credit in each of the cases, depending on how the court wishes to sentence him. He would have 114 days credit in 1550, 111 days in 1551, and 42 days in 1737. The 1551 and 1737 dates are included in the 114 in the 50-50 case. And we would ask for the restitution that I previously outlined, as well as we do think consecutive sentences are necessary to punish and protect. They wouldn't be disproportionate. He was on bond, as well as he has a history of criminal convictions that show that consecutive sentences are needed. And that would be the state's recommendation at this time.
Thank you. This court did review the pre-sentence report and investigation that was completed in this matter. I received multiple victim impact statements. I've read and considered all of those. I received a sentencing memorandum from Mr. Hinton. I've considered that. I've considered everything that's been said here in court today by the defendant, Mr. Hinton, Mr. Mario, the prosecutor, all the recommendations. I've also considered the particular facts and circumstances of each of the offenses involved here and the nature of the offenses. All of this is considered by this court in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, in all 3 cases, the court finds the defendant acted as a part of organized criminal activity, and that in each of these cases, the victims suffered significant economic harm, and several of them, many of them, suffered serious emotional harm as well. Small-time business owners are truly impacted on this, and that's not fair to them, and that's not right to them. And there's no reason that they have to deal with this. Many of these people took not just the monetary impact it had on them, but it took hours and hours of their time as well that to deal with different companies and trying to get back on track. And again, they did nothing to bring this upon themselves, and they did nothing to deserve any of this. No factors indicate that offenses are any less serious than normal. As for recidivism factors, I mean, I've been doing this a long time, and I don't remember seeing a record like this. You've been sent to prison 23 times. For 23 separate cases, you've been sent to prison, resulting in 12 separate prison numbers, meaning several of the cases were running concurrent to each other, and you got a break in that regard and weren't punished separately for those cases. You have 29 prior felony convictions. That's not counting 12 or 13 misdemeanor convictions, if I'm remembering correctly. Convictions in federal court. Juvenile delinquency adjudication, we have the DUIS. I mean, your criminal history goes back 40 years. 40 years. Just nonstop criminal activity, very similar to what we're here for. Aside from the time periods that you were locked up, this is what you do. Theft, grand theft, receiving stolen property. Just take what doesn't belong to you. And other people have to suffer because of it. And you don't think you should be punished for this. There are multiple times where you've been given help. You've been put on probation. And there's multiple probation violations. Heck, the last time you were in Veterans Court, you violated at least 7 times. And they just kept continuing you. And that's why you're back here, because nothing happens to you. But there's multiple times where you have failed to comply with previously imposed sanctions from this court. From courts. You say you want to be put on probation and you can get a job because you have a chance to work and you'll make restitution. You owe thousands and thousands and thousands of dollars still to other people for the crimes that you've committed before.
That was wiped out.
You've been ordered to pay restitution before, and that hasn't been paid. And I expect that you're going to pay the restitution in this case? Defendant contends there's a drug abuse problem that relates to the commission of the offenses. I don't know if that's accurate or not, but you put yourself into a program here this summer, and while you were in the program, you were committing crimes. No factors indicate recidivism is less likely. I mean, recidivism is guaranteed here because that's what the history shows for 40 years. But that's what you do. Prison in all three of these cases is consistent with the purposes and principles of sentencing. There's just no way this court can make any finding defendants amenable to available community control sanctions. Therefore, in case 25 CR 1550, it'll be the sentence of this court that on counts 1 and count 2, defendants serve a term in prison of 12 months on each count. Those terms shall be served consecutive to each other. Defendant has credit for 114 days he served. Court will further order the defendant in this case, at least I'll order the restitution. I don't expect it to get paid, but to Nicholas Svencara in the amount of $1,743.82, and to Bernard Gianetti in the amount of $3,188.09. In case 25 CR 1551, it will be the sentence of this court that on counts 1 and 2, grand theft of a motor vehicle. Then each of those two counts, the defendant be ordered to serve a term in prison of 12 months on each count to be served consecutive to each other. On count 3, the defendant is ordered to serve, this is the breaking and entering charge, a term of 9 months in prison. That will be concurrent to counts 1 and 2, but the prison term will be served consecutive to the prison term imposed in 25 CR 1550. Since it is consecutive, there's no further additional credit in this particular case, as that credit's been given to the defendant in 1550. In this case, the court orders restitution to Tyler Hart in the amount of $1,000, which is the deductible that he had to pay for his insurance company. The rest of the money was paid by the insurance company, and I guess I'm not allowed to order that, so that's free money for you. The court will also order restitution to the Ambrose Company in the amount of $8,572.85. Lastly, in case 25 CR 1737, it will be the sentence of this court that in counts 1 and 2, defendants serve a term in prison of 12 months on each count. On count 3, the charge of theft, defendants serve a term in prison of 6 months. Those will each be ordered to serve consecutive to each other and consecutive to the prison terms imposed in 1550 and 1551. There's no credit in this case, again, as that credit's already been given to the defendant in 1550. This is an overall prison term of 6.5 years in prison, with 114 days of credit. In this case, the court's going to order restitution to Joey Walker in the amount of $500 for his deductible, to Afrin Biddick in the amount of $6,925, and to Rad Air in care of Bill Snow in the amount of $4,138.99. Let the record reflect, none of these orders of restitution involve reimbursing the victim for the fence that was installed. I don't have the authority to do that. Just for the record, I know I'm well past it, but under recidivism factors, the court also finds the defendant was on bond when these occurred and had outstanding warrants for his arrest in several other cases when all these offenses occurred. I need to advise you, upon your release from prison, you could be placed on post-release control for up to 2 years. If you are and you violate any of these conditions, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by this court. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court further orders the defendant pay his court costs for each of these 3 cases. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Court further finds that consecutive service is necessary with all 3 of these cases to protect the public from future crime and to punish the offender. If they are not disproportionate to the seriousness of his conduct and to the danger he poses to the public, and that he committed one or more of these offenses while on bond, awaiting trial. In other cases, that at least 2 of these offenses were committed as a part of one or more courses of conduct, and the harm caused was so great or unusual that no single prison term for any of the offenses committed adequately reflects the seriousness of his conduct. And most importantly, the offender's history of criminal conduct demonstrates consecutive sentences are necessary to protect the public from future crime by the offender. Quite frankly, these are all separate offenses that you committed affecting separate victims, all who have been impacted by your criminal conduct, and they deserve to be punished separately. I'm not going to let you commit one crime and then just go ahead and commit a whole bunch and just run them all together and benefit from committing multiple crimes. These are separate offenses where you, again, seriously impacted the lives of many individuals, and they deserve to have separate consequences and separate punishments. I think that covers everything. Is there anything I omitted or need to address, Ms. Cutts?
No, thank you, Your Honor.
Mr. Hinton?
Your Honor, there's just 2 things that I'd like to be heard on. The first, Mr. Wilder, he did indicate to me, and this is just for clarification, but he thought that some of the restitution in the previous cases may have been addressed in an appellate case. I told him I would look into that, but he did want me to clarify that point with you so that you understand why he hadn't made restitution in those cases. On the second point is, Mr. Wilder does have family here. He was hopeful to have some sort of brief interaction with them, specifically his son, at the conclusion of the proceedings.
No, I never allow that. It's up to the Sheriff's Department, and I'm not going to, no reason to provide any exceptions for Mr. Wilder.
State of Ohio versus Martell L. Brooks, case number 25 CR 001543. Defendant is present in open court today with his counsel, Martinez. Your Honor, we're here today on a one-count information that was filed on January 23rd of 2026. That one count being domestic violence of the fourth degree. It's the state's understanding today that the defendant will waive his right to indictment, will plead guilty to the one count in the information, who has to defer sentencing so that a pre-sentence report, psychological evaluation, and victim impact statement may be ordered. And that is the state's understanding at this time.
Thank you. Mr. Martinez, does that sound accurate?
It does, Your Honor. I've explained to Mr. Brooks his constitutional rights he's going to be waiving here this morning. It's my opinion his plea will be made knowingly, intelligently, and voluntarily. Thank you.
Thank you. Mr. Brooks, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here at this time?
Yes, sir.
And you can be seated at this time. I don't interpret that as any disrespect. It takes a little bit of time. It's easier to be sitting down when we do this. So you're able to hear what they said?
Yes, sir.
They indicated to the court they believe it's your desire to waive your right to have this case presented to a grand jury, and I'll explain that in more detail in a moment, what that actually means. And then you'll be pleading guilty to the charge and the information, which I will also go over with you to make sure you understand that. We will then at that point defer or continue sentencing to a future day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they believe is the right and fair thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do here at this time?
Yes, sir.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, sir.
All right. Let's get started then. How old are you, sir?
27.
Are you able to read and write the English language?
Yes, sir.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, sir.
Are you a U.S. citizen?
Yes, sir.
Now, before you came to court here today, have you any drugs or alcohol of any kind?
No, sir.
What about in the last 48 hours?
No, sir.
Not even prescribed medication? Nothing?
No, sir.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charge you're accused of committing and what you're pleading guilty to?
Yes, sir.
And at some point you had a chance to look that over?
Yes, sir.
Now, in that information, you're charged with one count, and what's alleged here and what you'll be admitting to is on or about October 12th, 2025 in Willoughby Hills, Lake County, Ohio, that you didn't knowingly cause or attempt to cause physical harm to a family or household member with the initials of HS. It's further alleged that you have previously been convicted or pled guilty to domestic violence in Cuyahoga County back on April 18th, 2023. That conduct with the prior conviction constitutes the offense of domestic violence, and it's a felony of the fourth degree. Do you understand what you're charged with and pleading guilty to in regards to count one here?
Yes, sir.
Any questions for me about it?
Not at the moment.
Well, if you do have questions at any point, make sure you ask. But at this point, then, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have a right to have this case presented to a grand jury. So that document I just read to you is called an information. And what an information is, it's a criminal charge brought by the prosecutor's office without this case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest a person probably committed a criminal offense. Everyone here in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision, whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward on the charge brought by the prosecutor and the information, and your attorney has indicated he believes that's how you want to proceed. Is that correct?
Correct.
Well, before I can go any further, I need to have you acknowledge that here in open court, in writing, And I have in my possession here a one-page document called a waiver of indictment, which sets forth and explains everything I just told you about with the grand jury. And it indicates you want to give up that right. Before I can accept your plea, I need to make sure you understand the document, that you sign it here in open court. Now, my understanding is that before I came out here, you had a chance to go over that document with Ms. Martinez. Is that correct?
Yes, sir.
Mr. Martinez, is that accurate? Did you read that over with Mr. Brooks, review it with him, answer all his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Brooks?
Yes, sir.
So you understand what that document says?
Yes, sir.
Do you have any questions for me about it?
Not at the moment.
It also appears that you signed it. Did you sign it?
Yes.
Mr. Martinez, you witnessed that?
I did, Your Honor.
And you as well, Ms. Cutts?
Yes, Your Honor.
Very well, then I'll make that document part of the record. At this point, Mr. Brooks, I'm going to review with you all the other rights you have that you are giving up by pleading guilty. And you, first of all, have a right to have a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. Unanimous means all 12 of them would have to agree together one way or the other, whether you're guilty or not guilty. You understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, sir.
Now, if you had a trial, you'd have the right to have an attorney represent you at the trial. If you cannot afford an attorney to represent you at trial, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, sir.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it's her job, or she bears the responsibility, the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of the charge. And the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir.
Now, when I speak of this burden of proof, since this is a criminal case, that burden of proof is what we refer to as proof beyond a reasonable doubt. And that is the highest burden of proof there is in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of the charge. You understand that?
Yes, sir.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, sir.
Now, in order to try to do that, if we were going to have a trial, the prosecutor would bring witnesses to come into court to testify for the state, and they would answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and that's called cross-examination. He could ask him anything he wanted to, well, within certain rules. Do you understand that?
Yes, sir.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, sir.
Now, you'd also have the right of the trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, sir.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, sir.
Do you realize you're giving up that right?
Yes, sir.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, sir.
And since that's your choice, what that really means then is that nobody else can force you or make you, nobody could compel you to testify on your own behalf if you didn't want to. I can't make you testify, but more importantly, the prosecutor here is not allowed to call you as a witness, stand and answer her questions. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, sir.
You further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions. by pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, sir.
All right, well, do you have any questions at all then regarding these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Any questions?
No, sir.
Do you understand them all?
Yes, sir.
Excuse me, do you still want to plead guilty?
Yes, sir.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, sir.
Further, as a result of pleading guilty, the effect of that plea is that you'll be, first of all, found guilty by the court of the charge, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, sir.
Now, as far as possible penalties go that could occur at sentencing, you're pleading guilty to a felony of the 4th degree. This is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, sir.
Now, are you currently on probation or parole or PRC, any type of supervision to any other courts or agencies?
No, sir.
Even in a criminal charges pending against you anywhere?
No, sir.
If a prison sentence was imposed at any point upon your release from prison, you could be put on what is called post-release control, sometimes referred to as parole or PRC. It's a period of supervision you would be on after you completed whatever the prison sentence was. And in this particular case, it could be up to 2 years. Do you understand that?
Yes, sir.
And if you were on post-release control at any point, never violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, sir.
Now, aside from the possible prison sentence I just explained to you, there's other consequences or penalties that could be imposed. You could be fined up to $5,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable in this case. Do you understand that?
Yes, sir.
Now, a few moments ago, I explained the possible prison sentence you face. I used the word possible because prison is not mandatory with this charge. You are eligible for probation, or what we formally call community control sanctions. Do you understand that?
Yes, sir.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I will consider that if that's what you're asking for, but I'll look at all the information presented to the court, and I'll make the decision I think is the right thing to do. Do you understand that?
Yes, sir.
Now, if you are put on community control sanctions, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of those conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes, sir.
Further, if you are on probation at any point and never violate any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I can order more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did it at that point, again, it could be in that range I explained before, 6 to 18 months. And that could be consecutive to any other sentence you could be serving at that time if something else happens, or that you're being sentenced to at that same time if a new case gets picked up. You understand all that?
Yes, sir.
All right, lastly, before you are sentenced in this case, at the time of sentencing, when we do come back here, you're going to have the right on that day to say anything you want. Anything you'd like me to know or consider. Your lawyer can speak on your behalf. He's allowed to recommend the sentence to the court. The prosecutor also has a right to recommend the sentence to the court, and the victim has a right to speak as well. You understand all that?
Yes, sir.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to go along and follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, sir.
All right, do you have any questions for me then regarding the potential penalties you face by pleading guilty?
No, sir.
You understand all the possible consequences?
Yes, sir.
Do you still want to plead guilty?
Yes, sir.
Have you had enough time to discuss this case with Mr. Martinez, have him go over the reports with you, answer your questions, review any issues that there may be?
Yes, sir.
Are you satisfied with the advice and counsel of your lawyer?
Yes, sir.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty at this time?
No, sir.
Have you been threatened or coerced in any way to plead guilty?
No, sir.
Are you entering the guilty plea freely and voluntarily?
Yes, sir.
All right then, Mr. Brooks, any questions for me at this point regarding anything we just talked about? The rights you're giving up, penalties you're facing, what you're actually pleading guilty to? Any questions at all?
No, sir.
Do you need any more time to speak with your lawyer before we go forward with your actual plea?
No, sir.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the evidence would establish in this case if we did have a trial. I want you to listen to what she says, because I'll have some follow-up questions for you about that, all right?
Yes, sir.
All right. Ms. Cutts.
Thank you, Your Honor. Had this matter proceeded to trial, the state would have proven beyond a reasonable doubt that on October 12th of 2025, shortly after 10:30 p.m., the Willoughby Hills Police Department officers were dispatched and responded to the sheets located on Chardon Road in Willoughby Hills, Lake County, Ohio, for domestic violence. When they arrived at the location, they interacted with Hazel Strait, who is a family or household member of the defendant, Martell Brooks. The information she provided indicated that Mr. Brooks had knowingly caused physical harm to her. He was at that time her boyfriend and soon to be father of her child. She had indicated that they had recently moved from the defendant's mother's house and were now living in apartment 623 at 27400 Chardon Road in Willoughby Hills Towers, in Willoughby Hills, Lake County, Ohio. Officers saw visible red marks or scratches on her neck as well as on her hand. She indicated that she had been struck in the face as well as grabbed by the neck. She indicated that she had gotten up, grabbed her daughter who was with her at Sheets, and left. She was wearing a pink bathrobe only. Officers went to Willoughby Hills Towers, apartment 623, and made contact with the defendant. He did not have any visible injuries. He admitted he had a prior domestic violence conviction that was later determined to be Cuyahoga County Court of Common Pleas, case number CR 23-678-376, dated April 18, 2023. Ms. Drake did go to the hospital so they could monitor her, make sure that she was okay. She again informed the officers the injuries that she had were caused by the defendant. And that is the evidence the state would have provided, all occurring in Lake County, Ohio.
The victim was pregnant at the time?
Yes, Your Honor.
I know it's not a spec here or anything like that,
But you are correct.
just want to get the facts. Mr. Brooks, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we did have a trial?
Yes, sir.
What, if anything, do you want or have to say about those facts as she presented them? Are they accurate? Did you do what she said? Go ahead.
Yes, sir.
Very well then, regarding count one of the information charging with domestic violence, a felony of the 4th degree. What is your plea to that count at this time?
Guilty.
All right, I have in my possession at this time another document. This is a 4-page document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just discussed with you. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in open court. Now, my understanding is that before I walked out here, you had a chance to go over this document with your lawyer as well. Is that correct?
Yes, sir.
Mr. Martinez, is that accurate as well? Did you review this with Mr. Brooks? Read it to him, go over it with him?
I did, Your Honor.
Did he indicate an understanding of this document to you?
Yes, he did.
Is that correct, Mr. Brooks?
Yes, sir.
Do you understand what this document says?
Yes, sir.
Do you have any questions for me about the document?
No, sir.
Do you have any other questions for me at this time about anything we've discussed?
No, sir.
It also appears that you signed the document. Did you in fact sign it?
Yes, sir.
And Mr. Martinez, you witnessed that?
I did, Your Honor.
Ms. Cutts, you as well?
Yes, Your Honor, I did.
Very well, then, at this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect. The defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of all those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, domestic violence, a felony of the 4th degree in violation of 2919.25 of the revised code. I will defer sentencing, order pre-sentence report and investigation, victim impact statement. Mr. Martinez, are you requesting any other evaluations, drug and alcohol or psychological evaluations?
Yeah, we could do the psychological evaluation.
We'll do psychological evaluation as well, Mr. Shadowin? And I'll continue defendant's bond at $50,000 cash surety with the condition that he have no contact with the victim and GPS monitoring. So what all this means, Mr. Brooks, as far as bond goes, I'm continuing your bond. There's nothing more that you need to, nothing's changing in that regard. One of the conditions, aside from what I just said, is that you also can't use any drugs while you're on bond. You have to submit urine samples if requested by probation. They have to be negative. A positive screen will result in your bond being revoked and a warrant being issued for your arrest. Do you understand that?
Yes, sir.
Now, the purpose of these reports I've ordered is so I could learn more about you before sentencing. The way the probation department gets the information they need to prepare the reports is they're going to conduct an interview with you, a couple interviews. It's important that when you meet with them, you're open and honest with them because they're going to check and verify everything you tell them. And if they learn you're misleading them in any way, they'll let me know that, and I would obviously consider that at sentencing. You understand that?
Yes, sir.
All right, so what you're going to do now, you're going to leave here right now. You're going to go over to the probation department. It's over on the 3rd floor of the sheriff's department. You're going to fill out some initial paperwork, and you'll get your date to come back for the interview. So make sure when you leave here, you go right over there to do that, all right?
Yes, sir.
All right. Mr. Martinez, anything else for the record?
No, Your Honor, thank you.
Ms. Cutts?
No.
were present today in case 25CR1402, the State of Ohio versus Carla Ferrona. The defendant is present, represented by counsel Mary Catherine Corrigan. We were last before this court on January 26th when the defendant pled guilty to count 1 of the indictment, tampering with evidence with a 1-year firearm specification. The parties have had the opportunity to review the pre-sentence report and are prepared to proceed with sentencing today. Thank you.
Thank you. Ms. Corrigan, any reason not to go forward with sentencing?
No, Your Honor, I am prepared.
Anything you'd like to say at this time on behalf of your client?
Thank you so much, Your Honor. Your Honor, we would ask that the court consider imposing a minimum sentence or, in the alternative, a 1-year sentence on the underlying charge with 1 year on the firearms specification. Your Honor, in support of said request, we would highlight a few things for the court. Judge, I would ask that you take into account that from the get-go, Ms. Ferrona has been accepting of responsibility for her part in this case. While she certainly did something very wrong, and she does have a statement she's going to make for herself, when she was confronted with the police, she did help them find the firearm. She let them know where it had gone. Judge, from the first time I met her before her preliminary hearing, she said, "I will waive my preliminary hearing. I know I did something wrong. I'm not going to fight about bond." We had our first arraignment and pretrial. She's almost immediately said, "I will plea. I did something wrong." And Judge, especially in cases like this, especially with the, if you will, I don't want to demean the seriousness of her conduct, but certainly this started as an aggravated murder case. There's people with this, in this matter, charged with aggravated murder. And usually when you see the people charged with the lesser crimes, in my experience, those are the ones that hang on and say, "I didn't do anything, I didn't do anything." And Carla never did that. Your Honor, Carla's had an incredibly rough life. She has a dual diagnosis mental health issue as well as a serious substance abuse issue, her drug of choice being crack cocaine. She does know how to get herself in and out of programs, and she has worked them in the past. And I do expect that it is her intention to try to enroll in whatever courses are available to her, whether she ends up at Marysville, Dayton, or Northeast Ohio pre-release. And I hope, I'm not as familiar with the women's prisons, but I do hope she'll at least be able to get herself in a 12-step program and work it there. Mm-hmm. Your Honor, Ms. Ferrona, in part and parcel to the rough life she's had as a drug user and someone who's been in and out of jails, treatment facilities, and I believe prison, she also lost her child. Her son was in the custody of the Cuyahoga County Department of Children and Family Services. I think she had her parental rights completely terminated. However, she did maintain communication with her son, Christopher, after that occurred. Christopher had absconded from a group home in Cuyahoga County and became involved in this. And when he called her for help, I think she, in a bleak moment in time, just tried to do whatever she could do to help her son. And I think no matter what court orders say she is or isn't his parent, I think she'll always be his parent, at least in her heart. She went to the home. She went twice. On the second time, she found the gun in the bushes and then promptly took it back to Cuyahoga County, where it was traded for a drug debt of somebody who I do believe that she believed was a ally of hers, but over the course of my representation, it's become clear to both Carla and I that the man for whom she traded the gun for his drug debt, was really using her.
For whose drug debt? For her drug debt?
It was her ex-boyfriend, and she's happy to place his name on the record.
No, I didn't know if it was her debt or someone else's debt.
It was her ex-boyfriend's debt, Your Honor, and through the course of my representation of Carla, it became clear that, well, certainly that person was not responsible for Carla going into the bushes and Carla taking that gun. I do think she was, for some period of time, kind of under his thumb and under his control as well.
So this was her boyfriend at the time?
It was her boyfriend at the time. It was her boyfriend for even part of this case before it kind of all started to unravel. Your Honor, I think Carla has a letter she is going to ask you for an opportunity to read, wherein I think you'll hear just how remorseful she is for her conduct. But words are just words until you put them into action. And what I would argue to the court today and always is that her behavior as a defendant in the pretrial process of this court has been indicative of somebody who's not just talking the talk, not just here to say what you want to hear. She pled to gun specs knowing she was going to prison. She didn't ever fight about her bond. She told me almost immediately that she was going to plead guilty. I think all of that is demonstrative of the fact that she's not just saying these things, she understands them, and she knows that there are consequences to her actions. And unfortunately, I think now she's seeing that there's also going to be consequences to her son's actions, and that likewise breaks her heart. Judge, with all of that, I could just say from a personal standpoint, I know she's not ever going to be on probation to this court's docket unless you were to consider a judicial release at a later date. But my experience with Carla is one of the best experiences I've had representing people in 13 years. She's polite, she's understanding, she understands the course of the conduct that brought her here, she understands the decisions she's making, she understands the reality of life, the reality that lawyers are lives, or that lawyers have lives, that judges have lives, that we are all people that are here to do a job. And that is an incredibly empathetic position to take as a criminal defendant, especially one with this dual diagnosis mental health issues. So with all of that, we would ask that you impose a minimum sentence. Thank you.
Thank you. Ms. Ferroni, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, I would like to read my letter, please.
Go ahead.
Okay. Okay, so, I was hoping that the family would be here today, Your Honor. I wanted to look them in the eye so I could let them know how I feel. I'm sorry, I'm shaking about everything myself. This is big. Okay, so anyways.
Do you want me to read it?
Yeah, I can do it. It says, first, that I'm glad that the family is here, but they are not. So I'm sad that they are not here. So I can look them in the eye and say that I know that there are no words or actions other than bringing their son back that could ever relieve the pain of losing the child, family, and friend in such a terrible way. And I'm sad for you all. I'm so sorry about your loss, and no matter what kind of mother I have been due to my use, I would be just devastated if it were my own child. There is not a night or a day that goes by that I don't play this over and over in my mind. And if I could take it all back and give it all back, and give your child back and fix everything for everybody, that I would. My life hasn't been that much. I would give my own life, Your Honor, if I could fix this and give a child back. I was high when the phone call came in, and I really did not know what to do. I was never told the details, nor did I actually go to Fox Run Apartments till the next day. Christopher did not call me to ask me to remove the gun. He thought the detectives that had already had it. I want to make that clear. I was there for something else. But when I did come across the bag, all I could think about was my own child. My judgment was clouded by the time that by the drugs that I was on, and the fact that I was on medication, on no medication to rationalize my first thought. When it all came together, the fear in so many forms set in. I've never dealt with a situation of this magnitude before, and I did not know that a young man had died. All that I could thought of at that moment was to help my own child. And now not only can I not be there for my child, but I've made his situation worse by my own deluded judgments. My mother died on December 4th, and I'm not there to help with the goings-on of her funeral, nor mourn the loss with our family. My sister Lori was in a nursing home for 3 years and finally came home. I was supposed to be there to help her with those things. Instead, my first thought was wrong. That quick. The consequences have not only been great for me, but for many others. I've been working for years on my addiction, mental health, and trauma. And when I fall, I instantly put myself back into treatment for my mental health or addiction. 4 and 2 years, Your Honor. I do not want to be the menace or a monster that I've been labeled. I'm actually one that cares for others. I want to one day help others with what I have been through. I have obtained my CDCA, and I reach out to others when I can in many ways that you're not able to see, because all you're able to see, unfortunately, is the paperwork in front of you, which I want you to know, very embarrassed about. Please believe me when I say that I'm doing my best to heal. It is a daily reprieve, and yes, at times I struggle, but I always get back up and do my best to look at and find the positives in life that God gave me. I refuse to die a loser that has done nothing with her life. And unfortunately, this is not a situation that I can dust off in some kind of hospital or treatment to make it better. And I do take responsibility for my actions. Once again, and if you can let them know, I am very, very sorry to the family and friends. And whether they believe it or not, they are in my hearts and prayers continuously. And I am sorry for their loss. Thank you for listening.
Thank you. Ms. Corrigan, anything else?
No, thank you so very much, Your Honor.
For the state of Ohio, Ms. Tuttle?
Thank you, Your Honor. We're asking the court to impose a prison term in this case. The defendant does have credit for 158 days. She did plead guilty to the 1-year firearm specification. We would ask for a prison term consecutive on the underlying offense. The defendant has a lengthy...
What do you mean consecutive?
To the firearm specification.
Oh, well, it has to be, all right.
Yes. The defendant has a lengthy criminal history starting in 1997, going all the way through the instant offense. There really is no substantial break in her criminal history. She has a number of prison terms that she has served. She's had a number of opportunities in treatment, and nothing has really proved to be successful for her. The facts of this case are more serious than the average tampering with evidence. The defendant knew that this gun was used in a shooting. Her son knew that that shooting led to the death of someone. Her son gave her information when he made a call to her immediately after this shooting happened. He told her that his friend had shot someone, that he tampered with a gun, that he cleaned it with Crown Royal, that he needed it to be taken away, that he did something bad, that he tampered with evidence. The defendant knew all of that and chose to come to the Fox Run Apartments, chose to get that gun from the location where he told her that it was in the bushes, and on phone calls to her son and her son's girlfriend said things like, I got it, it's taken care of, I've handled it, I got it. And she said things like that repeatedly. So the defendant knew exactly what she was doing and exactly what she was taking and what her son was risking as a result of his own conduct. The defendant was not actually separated from her child at the time that this occurred, Judge. The place where this robbery and homicide was planned was actually the defendant's bedroom in Melvin Harris's apartment. The defendant's items were all still in that apartment. They were all still there. She had been living with Mr. Harris at Fox Run, as well as her son. So they had been in communication. They had been talking with one another. All of her personal items were in that room where this homicide was planned. The defendant was at the apartment only an hour before the Willoughby Police Department came to that apartment to search, to talk to people that were there, and to talk to her son. So she was there, she was retrieving items, she was retrieving evidence. Originally, she wasn't forthcoming and truthful with the police. It was once she didn't want to go to jail, she called the police back in and she began giving them truthful versions of events. But at first, the defendant was reluctant to tell them that she had any involvement, that she had any knowledge of anything. She told them that her statements of, I got it, were relating to getting an apartment, not about getting the gun that was under the bushes and the reason why her son was calling. So while I do understand and acknowledge that Ms. Ferrona wanted to do anything that she could to protect her son, that she wanted to watch out for him, that she wanted to be a mother to him, this was a serious crime that was committed using this firearm, and she had knowledge of that, which is why this is a more serious form of tampering with evidence, and we ask the court to impose that prison sentence. Additionally, we ask for count 2 of the indictment to be dismissed. Thank you.
This court reviewed the pre-sentence report and investigation. Those victim impact statements that were sent in, I've read those. I've considered the facts and circumstances of the offense involved here, the nature of the offense. I've considered everything that's been said here today by the defendant, her lawyer, the prosecutor, the recommendations from the sides. All this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. So the factors in 29-29-12, as for factors indicating the conduct is more or less serious, the court does note, as alluded to by the prosecutor, that the evidence that was tampered with in this case was a firearm that was used to kill a person. It was a firearm in a murder case. You know, the normal tampering with evidence case that we deal with is a person who's getting pulled over for a traffic offense and is getting rid of drugs that they have on them, throwing them out a window or trying to swallow them or whatever the case may be. Not necessarily, I think, the exact intent that that statute is designed for. Nonetheless, it's still a violation. But this, when people think of tampering with evidence, it's this scenario that people think of, and that you never get that. Hiding or getting rid of a murder weapon. And that's what this case is about. It's not just more serious, it's probably the worst form of the offense. Getting rid of a murder weapon. And interesting to me is that you say all you were thinking about was helping your son, we're also obviously thinking about helping your boyfriend, because you used that gun to then go take care and clear up a debt that he owed with his drug dealer. Instead of just getting rid of the gun, you took advantage of that, having that gun, to get some benefit to you and your boyfriend. Or at least him, but you helped him with it for that. I don't know how that'd be even a thought. I'll take this gun, but I know my boyfriend knows some money is this guy, so I'll give it to him and I can take care of that. No factors indicate it's less serious. As for recidivism factors, there's a lengthy history of criminal convictions. Goes back 30 years, 29 years. Defendant has served multiple prison terms before. She's been sentenced to prison on 5 separate cases that's resulted in 4 separate prison numbers. She's been on probation before in the past, has violated her probation on multiple occasions, so she's not complied with previously imposed sanctions ordered by courts. No factors indicate recidivism is less likely. It's mandatory prison term required due to the firearm specification. Prisons consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that on count 1, defendant serve a term in prison of 24 months. In addition, the court imposes a mandatory prison term of 1 year to be served prior to and consecutive to the 24-month prison sentence for an overall term of 36 months in prison. First year being mandatory for the firearm specification. Statute requires that the specification be consecutive, so no additional findings are required. Need to advise you upon your release. You may be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority could send you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, transfer to transitional control. I will dismiss count 2, and I will grant the defendant 158 days of credit that she is entitled to at this point.
Your Honor, again, once again, can you guys just please
No,
tell...
they're not your messenger.
I just want to tell the family, I'm sorry.
Yeah, well,
They will.
Okay, thank you.
I will.
Thank you.
I'm not ordering that. You can do whatever you want. It's not part of this. Is there anything else, Ms. Tuttle, on behalf of the state?
No, thank you, Your Honor.
Ms. Corrigan?
Yes, Your Honor, would you please declare my client indigent and consider waiving her court costs on this matter?
No.
Thank you.
We are here in the case of State of Ohio versus Justin Dam, case number 25 CR 1480. Defendant is present and represented by defense counsel Rachel Smith. Defendant has previously pled guilty to burglary, a felony of the 3rd degree, and possession of cocaine, a felony of the 5th degree with the forfeiture specification. Since then, a pre-sentence report and drug and alcohol evaluation, as well as an opportunity for a victim impact statement has taken place. We're here today for the sentencing.
Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you want to say on behalf of your client?
Yes, Your Honor. On behalf of Mr. Dam, we are asking the court to impose a period of community control. Mr. Dam is not opposed to and, in fact, expects the court to impose local jail time and or NeoCap should the opportunity for community control be granted. Your Honor, Mr. Dam has an extensive history, but from the beginning of this case, he's indicated that at this point in his life, he is trying genuinely to change in a manner that he has not in the past. Your Honor, prior to the instant offense, Mr. Dam had been released from prison back in May, had maintained 5 months of sobriety, was employed. He then lost his housing, ended up relapsing, and then committed the acts that bring us to court here today. Mr. Dam understands that his criminal conduct is a direct result of his drug use and that he needs to address both. Your Honor, Mr. Dam is present and has supportive family. His father, who he's been residing with since he was released from the jail, is currently present in the courtroom. It's my understanding that during Mr. Dam's past cases, his father was not always supportive because Mr. Dam did not always show that he was willing to change his behavior, change his ways and address his issues so that those changes last. Your Honor, at the expiration of Mr. Dam's Painesville municipal sentence, his father did bond him out of jail. Since while in the jail, Mr. Dam was connected with Signature Health and talking to Bree. He has expressed a strong desire for dual diagnosis help throughout the case, both with me and with various providers. Upon his release, he connected with Brightview and was to begin medication-assisted treatment and individual counseling. He was getting himself set up to start IOP, and although his previous job was no longer available, when his boss learned that he'd been released from the jail, called him and asked him to come back to work at one of his other locations. Mr. Dam has never been on probation as an adult, and he's 29 years old. He's single, he has no kids. He's asking the court, despite how things look on paper, to give him one opportunity as an adult on community control so that he can pursue a treatment path and address the myriad of issues that bring him in front of this court today.
Thank you. Mr. Dam, you have the right to address the court before your sentence. You can say anything you want. Is there anything you'd like to say at this time?
Yes, sir.
Good.
I know I've been in front of you multiple times, and I can't sit here and act like I didn't do what I did, because I did, and I'm trying to take full accountability of it. As I've gotten older, been to prison, I haven't learned anything from there. I just want a chance to do what's right for myself. My head space is different this time because I actually want it. I've actually been trying to put the work into doing it. Even though I did slip up and do what I did, I regret it. I tell my mom every day how much I regret doing what I did. I don't want to be here in front of you right now and saying what I'm saying, but I'm taking accountability for it, and I just want the chance to try to do the right things and prove to people that I can do the right things. Since I got bonded out a couple months ago, I've done everything my attorney has asked for, everything the court has asked for. Clean urines, going to all of my appointments, keeping in contact with everybody I'm supposed to. And I want to do the right thing. I don't want to keep coming in front of you. I don't want to ever come in front of you again. I don't want to be in this situation ever again. And I'm tired of it. And I just want to do the right thing. And prison isn't helping me. And I know that I don't need to commit a crime to get help, but I'm just asking you to please just give me this chance. And if I fuck up, or I'm sorry, if I mess up, I'm sorry. If I mess up, then I know what happens. I just really want this chance. And I please hope you can consider that.
Thank you.
And sorry for my language.
Ms. Smith, anything else?
Your Honor, Mr. Dam's father is in the courtroom, and I believe he wanted to address the court. Is that true?
Whoever it is, I would like to address the court. You can stand where it is that you're seated, state your full name, and say whatever you'd like me to know.
My name is Joseph Dam. I'm the father of Justin Dam. And I would like to say on Justin's behalf, once he was released from prison back in May, he immediately went out and got a job. And it was important for him to take on that responsibility. And he showed up every day. And what happened along that journey between him and his mother and her husband. But when Justin was released from jail, I gave him opportunity because he never had a stable roof over his head. So I decided to bring him into my home and give him a chance. And while he was there, I will say Justin has become very responsible in different ways. When he got that stability under my roof, he became more responsible. We've had many talks. Justin, I know, does not want this anymore. And I feel that hopefully the courts will consider getting him the help. The one thing about Justin coming home from prison, when he does, he would come back more messed up. His thoughts, his process of himself, very lost, very confused, dealing with everything he had to in there. As me and Justin talk, he took on the responsibility of hitting all his meetings. He's been doing good. He's been very respectful at home. Right now, at this time, I'm going through a lot in my life. And Justin has been there every step of the way to be at my side. Justin was never capable of doing that before. He's showing me growth. He's matured in certain ways. We talked about how he wants he wants that home one day. He wants a family. He's been very respectful to me, and it's been actually a pleasure having him around. It really has been. It's good to spend time with my son and seeing him grow. So I just ask the courts to please consider on that probation to give him that opportunity for NeoCap to let him get the help he really needs, because he really is trying. He's been trying very hard. And I will stand by his side. And he will have a home to come to. And I noticed that was Justin's biggest problem. He never had that stability of a home. So I decided to give it to him. And he's proven me right since he's been home with no problems. So that's what I have to say. And I just hope the courts will consider on getting him that help instead of prison.
Thank you. Ms. Smith, anything else on behalf of the defendant?
Your Honor, Mr. Dam has informed me that his mother is also present in the courtroom, and it appears that she also would like to address the court.
Can you state your full name, please?
My name is Mary Judash.
Can you spell that?
I'm Justin's mother, and
Can you spell your last name?
G-U-D-A-S-H.
Okay.
I am also the victim in this case. I just come here on behalf of myself and my husband to let you know that we do not wish for him to go to prison, that we wish for him to get some help. And we know how much he's grown. We've been able to see it. I've got a good relationship with him. And I'm just asking for the court to reconsider prison time and give him the chance that he deserves to grow. Thank you.
Thank you. Ms. Smith, anything else?
Not at this time, Your Honor.
All right. On behalf of the state, Mr. Gritsky.
Your Honor, the state recommends prison. In this case, the facts have been outlined, and change of plea hearing are also in the pre-sentence report. The victim, the defendant's father, is the victim of this, or stepfather, excuse me, is the victim in this case. State feels prison is appropriate because of the defendant's exceptionally long criminal history. For that, a long history of juvenile adjudications where there were failures to rehabilitate, and then his history, criminal history, at least with felonies as an adult, started with a burglary conviction for which he went to prison for in 2017. It was a theft conviction for which he also went to prison for in 2017. Shortly after he was released, he was convicted or committed another burglary. He was convicted and went to prison for that offense in 2021. Shortly after being placed on parole and being released from prison in that case, he committed another felony offense of attempted robbery and disrupting public service. He was sentenced to prison in that case in 2023. Then he was released in that case in May of 2025, which has been referenced a few times this afternoon. The defendant committed 2 misdemeanor crimes before committing this one. He was out on bail, at least in one case when this offense was committed. The defendant has not responded favorably to any of those prison sentences, but additionally he hasn't responded favorably to the community control sanctions that were placed on him in the municipal court for those misdemeanors, which he's received convictions for as well. There is a pattern of alcohol use related to this offense. The defendant has not, despite court orders, it's my understanding, again from municipal court, followed through with getting the treatment that has been court ordered. All this shows that he is not an appropriate candidate for community control.
Thank you. This court has reviewed the pre-sentence report and investigation. Drug and alcohol evaluation that was completed. I've considered the facts and circumstances of the offense involved, the nature of the offense involved. I have considered everything that's been said here today by Ms. Smith, the defendant himself, his mother and father, the prosecutor, recommendations from all the folks. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, the court notes that the defendant's relationship with the victim facilitated the commission of this offense. Nothing indicates it's less serious. As for factors indicating recidivism is more serious, almost all of these are present. The defendant committed the offense while he was on bond. He has a very lengthy history of juvenile delinquency adjudications and criminal convictions as an adult. I mean, the defendant's only 29 years old, and his criminal history goes back 18 years. 17 and a half years. Started when he was 12 years old. Lengthy juvenile history and just continued on as an adult. Failed to comply with previously imposed sanctions ordered by courts. drug abuse and or alcohol problem related to the offense, and he hasn't done anything to deal with it. In this particular case, he got out of prison in May. Within 3 months, he's back committing crimes. Committed 2 misdemeanor offenses and then this. 3 months. He says that he wants all this help, but he hasn't done it, anything to get it. Until crimes are committed and he's facing court for sentencing. He's put on probation for one of these misdemeanors and he violated already. Because he didn't do anything he was supposed to do. It's the same thing over and over and over. And I hear the same things. So I read and looked at the prior pre-sentence reports that I have, and you say the same thing. I want to get help. I need to get some drug or alcohol help. I need to get mental health help. And you don't do it. So you've said this stuff before. There are factors indicate recidivism is more likely. There's nothing indicating it's less likely. In 2913B1, defendants previously served a prison term. Prison is consistent with the purposes and principles of sentencing, and there's just no way this court can make a finding defendants amenable to available community control sanctions. Therefore, it's a sentence of this court that on count 1, defendant served a term in prison of 24 months. On count 2, he served a term in prison of 8 months. Those will be served concurrent with each other for a 24-month prison term. He has credit for 4 days that he served on this case. Any other time that was in the jail, he was serving his sentence for the misdemeanor offenses that he was convicted of. Upon your release from prison, I need to advise you that you'll be on post-release control for at least 1 year. It could be up to 3 years. While on post-release control, if you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control, and defendant's ordered to pay all costs incurred in this action. Is there anything else for the record, Mr. Gretzky?
A forfeiture of the items.
Whatever contraband and instrumentalities were in the specification will be forfeited as well.
Thank you, Your Honor.
I will release bond as well at this time. Ms. Smith, anything else?
Nothing to
case, State of Ohio versus Adam V. Kane, case number 25CR1196. The defendant is present today in court represented by Attorney Bill Watson. You were previously in court January 5th of this year. The defendant pled guilty to count 2, grand theft of a motor vehicle, a felony of the 4th degree, as well as count 3, theft, a felony of the 5th degree. This matter is then referred for a pre-sentence report, victim impact statement, and a drug and alcohol evaluation, and we're scheduled for sentencing today. Thank you.
One moment, please. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court, I'll be brief. I know the court's well aware of Mr. Kane's history. He's got quite an extensive history, been to prison before, and a lot of this stems from Mr. Kane's addiction to drugs and alcohol. On this particular offense, he was already on probation, I believe, out of Summit County. He was high, using drugs, thought it would be a good idea to take this trailer, did in fact take the trailer, drove it away some ways, and then changed his mind and said, you know, this isn't a good idea. Your Honor, ever since I met Mr. Kane, originally he was out on bond. He's told me that, you know, he knows he's been in and out of treatment. He knows he's got this problem, and he wants to kick it. He wants to try to get past this. Now, he did take responsibility on this case. We were here for a change of plea. I know he was sent over to probation, and unfortunately, he had tested positive, and there was a warrant out to revoke his bond. During that time period, on his own, and I'll give him credit for this, on his own, he went out and got himself into a treatment facility. I know he's been there before, different facilities, but he took the steps on his own, and then was picked up, on the warrant. He's here today. Your Honor, we're here hat in hand. I know he's been in front of numerous courts, probably saying the same thing, but he's been very sincere with me since I met him about how drugs have destroyed his life. I only hope that he's able to find peace and find sobriety. I'm respectfully asking the court to consider a 12-month sentence on this case. I know it has a lot of discretion as to what it can do today, but the fact that Mr. Kane did take responsibility and the fact that he did at least take his own steps to try to get into treatment, I'm hoping the court to take those factors into consideration. Thank you, Your Honor.
Thank you. Mr. Kane, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Your Honor, first I would just like to apologize for just committing this crime. I mean, it's absolutely embarrassing and ridiculous at this age and a point in my life that this has still continued to happen. If I could go back in time and change this, obviously we wouldn't be here, but what I can tell you is what I've done over the past year to try to change my life. Shortly after I committed this crime, June of last year, my daughter-in-law moved in with me and my wife, and she has a 1.5-year-old child, and she was also pregnant with twins. A week later, I checked myself into a drug rehab facility. I went through detox. I went through the 30-day residential program. I came home. I had started attending 3 meetings a week. I got a sponsor. I started working the 12-step program. Since I've been here in the jail, she had the twins a week ago. I'm unable to have any kids of my own, so being able to have these kids in my life, is nothing short of a miracle for me. I continued over the past year to do treatment, keep in contact with my sponsor. In December of last year, I did have a relapse that lasted about a week, and I put myself right back into New Day recovery. I came here to do my PSI from New Day, turned myself in from the treatment center to do my PSI here, which then they took me into custody. They still have a bed open for me there at New Day, and that's what I'm hoping to go back to treatment. I have 3 grandbabies living at my house right now, and for the first time in my life, I actually have a life. I've never in my life I don't have any kids of my own. I've never had a life to, even try to live for, but I have a wonderful girlfriend or wife, and she works at Talmadge Animal Hospital. She has a good job. I have a good job doing construction. We have a wonderful home in a nice neighborhood, and I got all these grandkids to be, out there trying to help. And I just want to. I'm so far from the person that committed this crime right now. I mean, for the first time in my life, I actually can see a life ahead of me without drugs and crime and everything. The past 30 years of my life, I've dug a hole, and I'm just trying to dig my way back out, Your Honor, and that's all I have to say.
Thank you. Mr. Watson, anything else on behalf of the defense?
No, Your Honor.
Swift for the State of Ohio.
Thank you, Your Honor. On behalf of the State of Ohio, I am recommending prison. This is a case where the defendant took a trailer that had a vehicle loaded on the trailer, hooked it up to his own car, and stole both pieces of property from the victim's business. He uses both the trailer and the truck for his business. The truck was registered in his name, and the trailer was registered in his wife's name. The defendant has demonstrated through his criminal history that he is not a good candidate for community control. He's been placed on community control several times before. He has violated, and he has 5 prior prison numbers. While he was given an opportunity for community control in the past, he violated his community control sanctions. When this case occurred, the defendant was on bonds in a Summit County case, as well as on community control to also Summit County. The defendant has demonstrated that he would not be an appropriate candidate for community control, so the state is recommending prison. The harm here is by depriving the victim and his wife of both of these pieces of property that they needed and that the defendant took without disregard for how it would affect the victim. The victim did submit a victim impact statement detailing his restitution request, which we discussed back in chambers, and the total amount listed is $4,970. However, I don't believe that he would be entitled to any restitution for additional tire locks, hitch locks, or lost wages. I don't think that is the spirit behind the restitution and permissible here. The defendant would also be entitled to 34 days of jail time credit, and I would dismiss the remaining counts of the indictment. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation, victim impact statement, drug and alcohol evaluation. I've considered the facts and circumstances of the offenses involved, the nature of the offenses involved. I've considered what's been said here today by the defendant, his lawyer, the prosecutor. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911. For the factors in 2912, Factors indicating the conduct is more or less serious. The court notes the victim suffered serious economic harm as a result of the conduct. Nothing makes it less serious. As for recidivism factors, almost all of these factors are present, indicating the defendant is more likely to commit crime in the future. Defendant committed this offense while he was on probation to Summit County and while he was on bond to Summit County for a new case. So he was put on probation in Summit County in July of 24 for 2 years. Committed this offense about 9 months later. He also picked up a new offense in Summit County in March and was on bond for that case when he did this as well. He's got a lengthy history of criminal convictions. Goes back almost 30 years. 48 years old, so it started right around being 19, 20 years old. It's resulted in, you've got 14 misdemeanor convictions, 12 felony convictions. He's been sent to prison on 5 occasions. He's not responded favorably to previously imposed sanctions ordered by courts. And he has been put on probation before in the past, multiple times, and he's violated his probation numerous times. He also has, in terms of traffic, normally I don't allude to traffic, but has your license suspended 55 times.
Yeah.
You've been convicted of driving under suspension 32 times. You clearly don't listen to authority or follow orders that were imposed.
I just
I've
went to
never
a
seen
class
anything
for
like
that,
this.
sorry.
Defendant violated his bond, using drugs while he was on bond. Those are all factors indicating recidivism is more likely. Nothing indicates that it is less likely. Under 2913B1, the court notes the defendant previously served a prison term 5 times. Again, was on probation and bond in Summit County when this happened. Those are all factors overriding any presumption for community control sanctions. Prison is consistent with the purposes and principles of sentencing, and the defendant is not amenable to any available community control sanction. Therefore, will be the sentence to this court. Then on count 2, defendant served a term in prison of 17 months. On count 3, served a term in prison of 11 months. I'll run those terms concurrent with each other for an overall term of 17 months in prison. He has credit for 34 days he's already served. I need to advise you upon your release, you may be placed on post-release control for up to 2 years. If you are and you're violating those conditions, the parole authority can send you back to prison as punishment for violating their rules for another, what would it be, 8.5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs incurred in this action. Will further order restitution to the victim. As alluded to, the victim requested a larger amount, but there's some of the items that he requested I don't have the authority to impose. So I've not including those. So the amount of restitution he's entitled to is $2,750, and I will order that. I'll dismiss the balance of the indictment, release any bond that may have been posted. I think that covers everything. Ms. Wood, is there anything I've omitted or need to address?
No, Your Honor.
Mr. Watson?
Nothing further, Your Honor.
Thank you.
All rise.
afternoon. The State of Ohio versus Jeffrey Woods, case number 25 CR 1505. The defendant is present, open court with his attorney, Mr. Urankar. We are here today for the purposes of sentencing. On a prior date, the defendant did enter a plea of guilty by way of information to one count of grand theft of a motor vehicle, a felony of the 4th degree. Your Honor ordered a pre-sentence report and a victim impact statement. The pre-sentence report has been completed, and we are prepared to go forward to sentencing today.
Thank you. Mr. Urankar, any reason not to go forward with sentencing?
No, we've received the PSI. We had an opportunity to review it. No additions, changes, deletions, or amendments.
Anything you'd like to say on behalf of your client at this time?
Your Honor, I'd like to go last. Mr. Woods does have a number of people here prepared to speak on his behalf. With the court's permission, I'd call them first.
We can hear from whoever you'd like to have address the court.
Pastor, if you'd stand up, state your name, spell your last name for the record, and then let the judge know anything you'd like.
Your Honor, my name is Albert Lewis, Sr.
Can you spell your last name, please?
Yes, Lewis.
And then go ahead and say whatever you'd like me to know.
Yes. Your Honor, first of all, thank you for allowing me to speak to you on behalf of Mr. Woods. Mr. Woods has been, since the incident, a part of our church. He has not only been a part of it, but he's been very vigilant about doing the next right thing. I'm not here to say that his actions in that case was to be pushed to the side, but I am saying that being a product of Lake County, given a second chance here myself, I had been given a second chance from the courts here 10 years ago. And today I can say that it worked. Not only do we have a church, but we also have a recovery community organization. We are very known, very respected in the community, and I had to earn that. But it would have never started if I hadn't got the chance right here in Lake County. I've been sober for over 10 years now, and from my understanding that Mr. Woods actually had the same problem, or have the same problem that I have and have had. I know that my testimony here on his behalf is not something that I can say that will sway the courts in any way. But I do know that given an opportunity to have a second chance to come out and really prove himself, that I can be the one to help him along this process. Thank you, Your Honor.
Thank you, Mr. Lewis.
Your Honor, next we'll ask John. I'm sorry.
Good afternoon, everyone. My name is Dr. Marnetta Lewis. I am the CEO and founder of Grace Recovery Cafe, a state-certified behavioral health agency that is in Slavic Village community, and a community in which we serve and surrounding areas. And we met Jeff, Mr. Woods, a few months ago, maybe 4 months ago. From that day to this day, as my husband said, he's been very responsive to the suggestions. I want to say that the disease, he recognizes himself of having a disease of alcoholism or addiction. One of the things I do understand is that it's an illness. It's an illness that needs to be addressed. And a lot of times, in that process, if you don't have the support needed, it's hard to move forward. And I'm just here today to put out on the table that if given a chance, we are willing to invest further in helping him, because he's a good person. And I know sometimes good people make bad decisions, me being one of them. And I came through a domestic violence situation over 20-some years ago, and God allowed me the opportunity to get my life together, have my children, and be able to help sow into other people with lived experience. We do have a training program that he is a good candidate for, to be right in the middle of the bed with NCBA. We're holding that space for him with the hope that he's given the opportunity to be at the hub, the recovery hub, every day, working in the midst of other peers and learning how to, to become a peer supporter. It's very important that we understand that he has a willingness to change, not just because he got in trouble, but I'm sure that contributed to it, but it takes sometimes traumatic experiences to wake us up. And I don't believe that going inside the walls is going to be the answer to that question. I'm just saying, I think that peer support and a circle of praying friends is what he needs. Where I talk to him on our one-on-one, he's never had that. He's never had that before. And that's why I'm here today, to just ask and put myself and us on the mercy of this court and ask if you, because we will stand to be responsible. And everything we've said today, we can prove it. We've been on 19 Action News for the work we do in the community. We mentor the youth. We have a senior day program. We do a lot to help people. And he's one of many that we've touched in over the years. And so with that, I thank you for listening. Any questions you have for me, I'm open to them. And thank you for your time.
Thank you, ma'am.
You're welcome.
State your name, spell your last name.
My name is Johnny Compton, and I am a member of Alcoholics Anonymous. And Your Honor, thank you for letting me speak today. I have known Jeff Woods for a number of years, and I've seen him come in and out of the program, and I never really had much, how do you say it? I never really thought that he really wanted what we had. I always thought that he was further on motives. However, this last time since he's been back, he asked me to be a sponsor whenever he first got in trouble, and I said, no, I won't do that. And a month or so down the line, I asked him, I told him that I want to. And I've seen the change in him. I've seen the change in his eyes. Went through the steps together. He done a thorough full step in the program of Alcoholics Anonymous. And then he went with my priest over Father Vincent in Augustine's church, and he done a fifth step. Usually when they go in to do a fifth step, it takes them, 30 minutes, sometimes 40 minutes. He spent 2 hours, and Father Ben said that it was just a real thorough fifth step. And the fifth step is one of the most important steps on this. And I just feel that if you was to have the opportunity, Your Honor, a second chance, and I know that he's been in trouble, I know his history, and I know that we're betting against the odds, but I'd almost be willing to guarantee that you wouldn't see Jeffrey back in front of you again. He's involved with his children again now, and what an amazing thing to see. Him running around with his kid, what are you doing? I've got to go pick up the kids, and he brings his kids to the meetings, his boys. It's been remarkable what I've seen in the last several months, you know. And I know that he's on the spot, but I have faith that Jeff will continue on, even if you give him the chance, Your Honor. And I thank you for letting me talk. God bless you.
Thank you.
Respect any decision you make.
Ma'am, state your name, spell your last name for the record.
Hi, my name is Tiffany Farnham, F-A-R-N-H-A-M. I am Jeff Wood's ex-wife, and I didn't think that there was a change. I've known him 13 years. We have a child together. It's time in all these years that I've seen something different in him. With the support of the church, First Most, and AA, I think that he definitely deserves a second chance. I'm proud of who he is today, and I'm proud that he does have a relationship with our son now. And I want that to keep growing. I think him continuing on with what he's doing with AA and church, I think that he's on the right path, and I don't think that you'll see him here again. Thank you.
Thank you, Ms. Barnum.
Thank you, Your Honor. I think here today, it's refreshing to see that Jeff has so many people supporting him and so many people speaking positives about him. I think there's a great many times that I've come to court and there's not anybody standing in the back supporting the defendant, let alone multiple people sitting back there. I think everyone's touched on that Jeff does have a record and everyone understands what that record looks like. But I think what everyone's trying to explain is that Jeff has made some very substantial changes. He does have the right people around him. He does have support. Additionally, Jeff did bring a personal check with him. It's his intention to pay restitution in full. He tells me he has the ability to do that. He's going to go to the bank, I believe Chase Bank, and secure a money order or a certified check so he can turn it into probation as soon as he is able. I'm sorry?
He does not have that with him today.
He does not have a certified check or money order. He tells me even if there is an increased amount of restitution owed, greater than the $1,056.98, he would be able to pay that in full. And it's his intention to pay in full. I believe the PSI also covered a number of the issues Mr. Woods has attempted to overcome over the years, that there's a history of trauma, that he's been through the centers for treatment, that he is working through a MAT program, that he's working through a counseling program, that he's working through bipolar. So we do understand the significant history associated with Mr. Woods. Mr. Woods is hopeful that there will be some mercy from the court here today, that the current situation he finds himself in, that he's been able to create for himself after he created this situation for himself, we're hopeful that the court will view that favorably. Thank you.
Thank you. Mr. Wood, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Sure. Thank you. If I look at my record, nothing I could say here is going to make any difference, but yeah, I am not that guy anymore. And about the check, I didn't know that I couldn't pay with a certified check. But I didn't know if I'm going to go to jail today or what was going to happen, but I have the money in my pocket. I can pay in cash. That's not an issue with the restitution. I can take care of that. I intended to do it before court, but as I stated to my attorney, I don't know who it was supposed to go to. I didn't know if I was supposed to see the clerk or what. I didn't know, but I got it on me. That's not an issue. But yeah, I'm not that guy. I've ran my whole life. I mean, I've been in front of you before. I've ran my whole life due to drugs to cover up for, my father leaving me, sexual abuse as a kid, mental abuse. I mean, there's an array of things that's happened to me my whole life, and I ran to drugs to cover that up because, for whatever reason, embarrassment, just not wanting to reach out to nobody for no help. Finally, this time through counseling, good people in my corner that's went above and beyond for me. At a cafe, I spend a lot of time there. I do a lot of volunteer work. The pastor has a security firm. I work as a security guard for Morbido's Trucking now. My ex-wife would never even let me in the house if she didn't see a change. That's just not her MO. She's just not going for it. She's never been involved with criminal activity or drugs or anything in her life. I spend time with my kids. My sister, as I forward a letter to you about my sister, I'm her caregiver. She has no support at all except me. I take care of everything. Only thing I don't do for her is bathe her or help her in the bathroom. Everything else is solely my responsibility. The house is in my name, the apartment. Like right now, if I was to go to jail, she's calling right now, texting me, scared to death. She's like, what am I gonna do? I don't know what I'm gonna do. She has nowhere to go. She's on Social Security. She's stage 4 COPD. Like I said, if I look at my record, there's not much I can say. I am truly sorry. I made a stupid mistake. I'm willing to pay for it, and whatever you decide, I appreciate your time listening to me, and I respect, whatever you feel you have to do today. And like I said, no matter what, as soon as court's adjourned or however we can arrange it, even if I'm back there, whatever, I can pay to, Mr. Patel. I just didn't know where and what to do with it. But I brought it, like I said, I have the check right here, but I also have cash in my pocket. If I leave here, I can walk out the door with the officer and pay it. It's not an issue.
Thank you, sir.
Thank you.
Mr. Ranker, anything else?
No, thank you.
Ms. Contour for the State of Ohio.
Thank you, Your Honor. The state is recommending prison in this case. Mr. Pennell was working at Excalibur Towing, and it was a crime of opportunity in this case. Mr. Woods and his co-defendant, Mr. Banks, came to Excalibur Towing. They saw Mr. Pennell's truck as well as his ATV in the back of the truck, saw that the keys were in the car, and made a decision and a plan in order to steal it. They stole both of those items. The ATV was found in the front yard of Mr. Woods' home. The truck was found a few streets over, and I think that it was very quickly that those items were found, and I think that was through the work of the Willoughby Detective Bureau that those items were able to be recovered at all. He had just gotten out of prison in November of 2024. This occurred in August of 2025. By my review of his pre-sentence report, I counted at least 15 felony cases as well as at least 6 prison numbers, so his history does not recommend him for community control sanctions in this case. At the beginning of this case, I made an agreement with Mr. Urankar for restitution in the amount of $1,056.98. That was reported to the Willoughby Police Department in a police report of items that were missing from the vehicle when it was recovered. Since then, Mr. Pennell did provide me with 4 invoices. I believe I actually left my copies with Your Honor. That was an additional $1,985 in towing and storage services. I was able to call Excalibur. I got a hold of them last Friday. I talked to the manager there, who used to be Mr. Pennell's boss, and he confirmed that all of those invoices and charges were all accurate, and that those are all in order, Your Honor. So with that, the state would recommend prison.
Thank you. This court has reviewed the pre-sentence report investigation. I've considered the facts and circumstances of the offense involved, the nature of the offense. I received multiple letters in support of the defendant. I've read and considered those. I've considered everything that's been said here today by the defendant, his lawyer, acquaintances that are here. And I've considered the prosecutor's comments and recommendation. All this is considered in light of the purposes and principles of felony sentencing set forth in 2911. For the factors in 2912, the court notes the victim suffered economic harm as a result of the conduct involved here. Nothing makes it less serious. As for recidivism factors, this is obviously where the problem lies here. Defendant has a lengthy criminal history. Goes back $40 years. And it's just continued on from 1986. You look at the record here. It's just every year, yearly. So for the time he's in custody, same type of stuff. Theft-related charges, more serious stuff, felonious assault. For the most part, theft-related charges. All in all, been sent to prison 15 times in 15 cases, a total of 6 different prison numbers, so several of those were concurrent, but 15 separate cases that you've been sent to prison. And you just continue this. I mean, you just got out May. You got out November of 24.
Yes.
9 months later, you're committing another offense. And that's just, this new offense that we're here for is just, what, 6 months ago. I'm not sure when you became the new person that you say you became. You committed this new felony just 6 months ago. And people talk about getting a second chance. You've been given multiple chances. It's not like you've never been given chances before. I gave you a chance when you were in front of me before. I put you on probation before when you were in front of me. Despite having served prison sentences. You came before me and I put you on probation. Judge Mattia put you on drug court and kept you on drug court even though you violated and even though you've been to prison multiple times. So it's not that you haven't been given chances. You've been given chances. A lot of chances. You've been on probation several times. You've had treatment. It's not like something was said about never have had a chance at treatment. You've had plenty of chances at treatment. And what you're saying today is the same thing that you've said before. So it's the same thing you told me when you were here last time. I looked at the prior pre-sentence report from when you were here before. Same stuff.
Could I say something?
Sure.
I'm sorry. Yeah, I never took responsibility. That's why I said at the beginning, I've ran my whole life. I never took responsibility.
What do you mean you never took responsibility?
I've always went to prison. I've always went to prison. I jail well. Jails never did anything for me.
You haven't always gone to prison.
No, not every time. I don't mean it like that. But I usually end up in prison some way.
Yeah, because you get probation and you don't follow the rules. You don't comply with and do what you're supposed to do.
Because I never accept the responsibility for my actions, really. I never really got serious and said, okay, this is it. It's over with. I can't do this anymore. I never reached my bottom. I did that this time.
How do I know that? You've said this before. You were here before me last time and you said the same stuff.
I was dealing with an issue with my sister, or my mother passing away at that time, yeah. Yeah.
I'm not going to debate you.
I know,
but
I don't mean that. I don't mean it.
But the facts speak for themselves, and I don't want to make it sound like you've never been given a chance before. You've been given plenty of chances before. And this just occurred. You got out of prison in November, and less than a year later, 9 months later, you're committing another crime. And that occurred just 6 months ago, and I'm supposed to accept the fact that all of a sudden there's been some big change and you're a completely different person after doing the same stuff you've done for 40 years. Again, for the recidivism factors, there's an extensive criminal history. The defendant has failed to comply with previously imposed sanctions ordered by courts before. On multiple occasions, he's been put on probation, given chances at treatment, and is violated. So a lot of the prison sentences that he had is after he was given a chance. There's no factors indicating recidivism is less likely. Under 292913B1, again, the defendant has previously served a prison term. Prison is consistent with the purposes and principles of sentencing. And there's no way this court can make a finding, which I'd be required to do before I put you on probation, that you're amenable to community control sanctions. You've demonstrated over all this time that you're not. Therefore, it is a sentence to this court that on count one, defendant served a term in prison of 16 months. He has credit for 18 days he's already served. I need to advise you upon your release, you may be placed on post-release control for up to 2 years. If you are and you're violating any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 8 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence today. Court disapproves the defendant's placement in permanent shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs. I'll release the bond that was posted. I'm going to order restitution in the amount of $1,056.98. Ms. Contra.